get some remarks here, some welcoming remarks, and then we'll get right to it. So the UNH Patent Trademark Resource Center, in collaboration with Professor Lembry, Director of the IP Clinic, is glad to welcome you. And in the audience, we have students and we have faculty members, we have attorneys and paralegals, we have people from business, we have trademark applicant, at least one, and we have our small business development rep. Hi, how are you? So we have a really interesting audience here today too. And this is the final event in the visit from Attorney Craig Morris from the USPTO, where today it's a toasty 40 degrees in Alexandria. I checked that before I started today. And another thing to mention that's interesting, in his presentation yesterday on non-traditional trademarks, we found out that he was the examining trademark attorney on the application by Pepperidge Farm for the color orange of the goldfish cracker. So that was really interesting. So Attorney Morris works in the Office of the Commissioner of Trademarks. He currently is the managing attorney for the Trademark Education Outreach Program, spearheading the effort for increased USPTO educational activities in the area of trademark fundamentals. Mr. Morris has been with the USPTO since 1983, previously serving as an examining attorney, a senior attorney, and a managing attorney. And I'm happy to say this is his second visit to our campus during his tenure. So I'd like everyone to welcome Attorney Morris.
Thank you very much, John. I begin perhaps in an unusual place, Shakespeare's Romeo and Juliet, Act 2, Scene 2, where Juliet ponders what's in a name. That which we call a rose by any other name would smell as sweet. I fast forward to an executive of the Coca-Cola Company who knows exactly what's in a name. He was once asked, what do you consider your company's most valuable asset to be? He said, without question, it is our registered trademark. We could lose everything that we have as a business, be able to build again as long as we still had that registered mark. Most small businesses, most new entrepreneurs, they fail to view the value of a trademark in that way. Many are so focused on, for example, the patent aspect of their business that they fail to realize to take that to market, most likely you're going to have a trademark. Or the business person will say, you know, I don't need a trademark. I already have my domain name registered. Well, what's a domain name? Simply a URL, a way to find someone on the internet. Certainly important for a business, but it does not give trademark protection. Or they'll say, I already have my business name registered. Well, true, to do business in New Hampshire, you're going to have your business name registered, but that is not the same as having trademark protection. So today we're going to look at just trademark fundamentals, and I know for most of you this is going to be common ground, but it's sometimes good to kind of have an overall refresher and in part to hear the perspective of the USPTO. So, right off the bat, what is a trademark? Well, it's any word, it's any symbol, it's any design. It's really anything that serves the function of identifying the source of goods coming from one company from those coming from a different company. Now, yesterday I did give a talk on non-traditional marks, color, sound, shape. All of those things can serve the function of being a source identifier. But we're really going to focus on really the basics. Now, right off the bat, you might be thinking, well, what if I don't have a good? What if I don't have a product? Instead, I have a service. Well, then technically what you have is a service mark. Trademark protecting goods, service mark protecting services. But for simplicity, so each time I don't have to say trademark or service mark, just think that the concepts cover both. Now, once you realize that in fact it is a trademark that you need, well, you're going to have to figure out what is the form of that mark. It's probably easy to look at examples. So this handout shows the 4 possible variations. These variations are coming up in the construct of applying to seek registration. Not really how they're necessarily used, but if you're going to apply to seek registration, how might the mark appear? Well, the first example is what we call a composite mark, consisting of words and a design element. The second is the standard character format mark. What is meant by that? Well, that means that you're applying to seek registration to protect words alone, but you don't really care about the manner of presentation. Contrast it with the third example where you're very interested in the particular display. That's the stylized presentation. Again, that particular example of Coca-Cola, that's one of the most recognizable in the world. Finally, the fourth is also from Coca-Cola, popularized by the use of polar bears around the holiday season. They do have a registration for that, where it consists of just a design alone. Now, once you have in your head what the mark is going to be, what's one of the very first considerations? It's to make sure that the mark you are adopting is not going to cause a likelihood of confusion. That's confusion as to the source of those goods or services. What do we look at to determine if, in fact, a likelihood of confusion does exist? We look at 2 specific things. First, are the marks confusingly similar? Notice I didn't say, are they identical? Are they simply similar? And second, are the goods or services somehow related? Again, I didn't say, are they the same, but are they related? Sometimes it's helpful to look at an example to see how we do this analysis. Second page of the handout. So the first mark we have is X-seed for agricultural seeds. The second mark, do you see what the problem there is? Does it look anything like the first? No. But if you say that out loud, don't they pretty much both sound the same? X-seed, even though they look different, they are phonetically equivalent. That's enough to conclude that the marks are, in fact, confusingly similar. Is there a likelihood of confusion? Well, we don't know yet. We know that the marks are similar, but we have to look at the goods. So the first was for agricultural seeds. The second for live plants. It's possible in the same retail location you could buy both seeds and plants. So we would say those goods, in fact, move in the same channels of trade and are related. As such, overall, because the marks are confusingly similar and the goods are related, we would conclude that there is a likelihood of confusion. Again, always remember that both prongs of that test must be present. Confusingly similar marks and related goods or services. That's why it's possible for the identical mark to coexist in the marketplace without any problem, where the goods or services are totally unrelated. Again, both parts of that test must be present for there to be a problem. Now we have another example there. Lupo and wolf. Does anyone speak Italian? Well, even if you don't speak Italian, you can probably guess that lupo translates from the Italian into the English word wolf. 2 totally different languages, yet we would say those marks are confusingly similar. Again, is there a likelihood of confusion? Well, we have to look at the goods. Here we have pants. Other side, we have shirts. Clearly related, both clothing items, so overall, a likelihood of confusion. Now, why is it important to even avoid a likelihood of confusion? Well, let's see what could happen. You're about to launch a new product, and in the mail you get a letter. In legal terms, that letter is called a cease and desist letter, which is basically a fancy way of saying, stop it. Stop using that trademark because we believe that it infringes on our mark. Now, what do you think most people do when they first get such a letter? Right. Goes in the trash. They say, I don't know who this company is. I don't know why they're bothering me. I'm just going to ignore this. A few weeks later, the same letter shows up. Now it's on the letterhead of a law firm. Catches your attention a little bit more. So you think, well, I better not throw this away. Maybe I can just reach out to that other company to see maybe we could work this out. You say to them, what is your main concern? Well, they say, you know, we see what you're doing right now, but we're a little worried that you might expand your product line and get too close to what we're doing. You say, this is the only product I have now and that I will ever have. Well, they say, how about if we put that in a contract? They draw up a contract where it spells out you're going to do X, they're going to do Y. You're going to coexist in the marketplace. Good result. Quite honestly, it usually doesn't work out that way. Instead, where do you think this ends up? Court, right? Where does any dispute end up where the two parties cannot come to an agreement? In court. So now you're before a judge. The judge is going to make a ruling, and in fact, the judge may find not only is there infringement, but that you actually adopted your mark to steer business from yourself, from that company to yourself, okay? Based on the adoption of a confusingly similar mark, trying to steer business from them to you. So the judge may rule as follows. First, all product inventory bearing that confusingly similar mark must be destroyed. Second, all advertising material must be destroyed. And third, because you apparently adopted your mark to steer business from them to you, the judge may order that you pay punitive damages. Do you see what's happened here? Before you've even launched your business, you're basically out of business. You have no product, you have no advertising, and now you have no money. Which is why for a new business, it is critical to avoid the possibility of a likelihood of confusion. How do you do that? Well, the first thing you need to do is a trademark search. What are you searching? Well, you're searching the USPTO database. At www.uspto.gov, we offer the Trademark Electronic Search System, or TESS for short. Now, the good news about TESS is it is a free online search system, available 24 hours a day, 7 days a week. The bad news, it is only as good as you, the searcher. Let's go back to our example. So your mark is the first one, X-seed. So you think, I'm going to search this. So you go into TESS, and in the search field, you type X-seed. You hit submit. It comes back, no results. You think this is great. I have now done a search of the USPTO database. There are no results. I can move forward. We know there actually was a result that should have been found, that other X-seed mark. It was not picked up because the search was too literal, searching for the identical trademark, and that was it. A good search is one that's out of the box, where you're projecting, what if, and I don't know, but what if this other mark existed? I want to find it in my search. How can I craft my search to pull up those other results? It's maybe at this point you realize, I'm not a professional searcher. I know the consequences of my missing another mark. I think I better turn to a professional. So you might contact a trademark attorney or a professional search firm. What's the difference between the two? A trademark attorney may, in fact, use a search firm to do the mechanical searching, but what does the attorney bring to the table? The attorney is going to get back maybe 100 results. The attorney is going to do an analysis of those 100 to see, are there any that are truly problematic? Of the 100, the attorney may tell you, I want to discuss these 3 in particular. The first one, the attorney will say, a little concerned, but I feel maybe 90% chance that we could prevail. Say 90%, I'm good with that. The second, well, maybe 80%. 80, not as good as 90, still probably okay. The third one, the attorney may very well say, at best, 50-50 here. I'm just not sure what would happen. Now, at this point, you have to ask yourself, what kind of person am I? Am I a Las Vegas kind of person who's willing to say, 50-50? I still like those odds. Let's roll the dice and see what happens. Or you may say, 50-50, I'm just not comfortable. I want to choose a different mark. What the attorney is doing is helping you through that decision process. Contrasted with a search firm. Again, they do the mechanical searching. They then turn over those 100 results to you and say, good luck. They are not going to help you through the analysis. So maybe you understand what the analysis is. You know that you're looking for a confusingly similar mark and related goods or services. Maybe you can do that part yourself. Again, it's really your comfort level, but those are your 3 options. Searching through tests on your own, using a trademark attorney, or using a private search firm. Now, to make this even more complicated is the fact that under US law, there is no requirement that you seek federal registration. Through use alone, you get what is known as common law rights. If you search the USPTO database, that is only a search of registrations and pending applications. It has nothing to do with the common law. To do a common law search, what do you think you do? How do we search for anything today? Google, Yahoo, whatever your preferred search engine is, but through the internet. This certainly has made trying to find common law use easier than it used to be. You're looking for a story about a business somewhere, again, using a similar mark for related goods or services. Now, it used to be, and it still is the case, common law rights are tied to geographical use. So you used to be able to say, well, I did find a story about a company. They're based in San Francisco, and I think their common law rights are only tied to that particular area. So they're in California, I'm in New Hampshire. I don't think that there's a problem. The problem, though, is obviously the world has changed. Almost any business today is going to have a website. So yes, they're going to be based in California, but their reach is now much broader. So common law usually has broader implications than it did in the past. And again, always remember that common law, where the use was before your use, is going to trump you, even if you get a federal registration. That's a concept that, quite honestly, freaks a lot of people out. They say, I went through the whole process of the US government, I did get a federal registration, and now you're telling me that someone has superior rights through the common law? That is true and correct. That's simply how, under US law, it works. Now, knowing that you can have these superior common law rights, what is a natural question at this point? I know you're all thinking it. Anyone? Well, okay.
Well, why bother getting a trademark if common law is going to...
Gold star over here. Why bother getting a federal registration if you can have these common law rights that apparently are very important? The reality is, through registration, you can get things that you're never going to have through common law. First, you're going to have prima facie evidence that in fact you are the rightful owner of this mark throughout the entire United States. What is that evidence? It's your registration certificate. How might this come into play? Well, let's say unfortunately you end up back in court. You're now before a judge. Well, in any proceeding, you are allowed to introduce evidence. So as a matter of evidence, you're simply going to present your certificate. Now, quite honestly, not all judges are well versed in trademark law. It's not that you're trying to fool the judge, you're simply giving him something to consider. The judge may very well look at this certificate and say, well, it says on the top, the United States Patent and Trademark Office. Where it says owner, it has your name. And then I see it has this beautiful gold seal on it. This looks really important to me, and I think this does establish that you are the rightful owner. At this point, you are not going to raise your hand and say, but Judge, don't you want to consider their superior common law rights? You're going to sit there in silence. The judge is going to rule in your favor based on that certificate. So that's a very important thing for you. The second thing is, if you have that registration, you are going to be in the USPTO database, which means if someone knows enough to do a search, they're going to find you. By finding you, that may be enough for them to say, darn, someone already has the mark that I wanted. I need to now change my mark to something else. You didn't have to do anything. You did not have to take that party to court because on their own volition, they changed their mind about what their mark should be. Your problem disappeared for you by merely being in our database. Third, if you ever become aware of counterfeit goods coming into the country, you're able to present that certificate to Customs and Border Patrol. Again, they need a basis for keeping those counterfeit goods out. That registration certificate is their basis. There's some other things, but those are the three main reasons why a registration will always give you something concrete that you're not going to get through common law alone. So that's really the first big consideration in terms of mark selection, making sure that you're avoiding a likelihood of confusion. Second big consideration, making sure that the mark that is being adopted is a strong trademark. How do we know if a mark is strong? Well, we look at different levels. The highest level, the strongest marks, are those that are either fanciful or arbitrary. A fanciful mark is something like Xerox, Kodak. Those words never existed in our language until a marketing professional said, I'm going to put these letters together to create this word that's going to be a source identifier. Because those words were created specifically for that purpose, to be source identifiers, they are considered very, very strong trademarks. Equally as strong would be an arbitrary mark. Arbitrary in the sense that the mark is a real word, it's in the dictionary, but as related to the product or service, that relationship is totally arbitrary. Apple for computers. Apple, obviously, in the dictionary, real word, but relative to computers, that relationship is totally arbitrary. In fact, the Apple mark has now supplanted the Coca-Cola mark as the strongest mark in the world. People will contact my office when they see someone has applied for a mark that, again, is just a regular word, and they say, well, how can that be? That's simply a word in the dictionary. Well, fortunately, we say, oh, you mean like the word apple in the dictionary? The strongest trademark in the world? So, oh, okay, I guess we never really thought of it that way. Next level down, suggestive. Suggestive is a mark such as copper tone for suntan lotion. That word suggests that if you use that lotion, your skin will turn a beautiful copper tone. You have to think about that just a little bit. And if you do have to think about it a little bit, it's probably suggestive. Rather than the next level down, descriptive. A descriptive mark is one that comes right out on its face. It describes a characteristic, a quality, a function of the goods or services. This, for example, would be creamy for yogurt. If you went into the supermarket and you're standing in front of a shelf of yogurt products, the first says creamy, the second creamy, the third creamy. By the time you get to the 10th, that also says creamy on the front, is it very likely that you're going to say, oh, but that is the source identifier for this particular one? Not that likely. You're going to think, well, just like the others, that's telling me the consistency of this yogurt product is creamy. Descriptive marks are difficult to register and difficult to protect. Not impossible, but difficult. With that said, why do you think that many new businesses adopt descriptive marks? Most likely it's because they are working with a marketing person. Marketing people love descriptive marks. Marketing people will tell you descriptive marks are very good for you because you don't have to spend as much time, as much money educating your consumer as to why they'll want to buy your product or use your service, because they're going to get that looking at the mark. From a marketing perspective, that does perhaps make sense, but always remember, trademarks are legal things. In an ideal world, marketing and legal would work hand in hand. Unfortunately, that's usually not the case. So if someone tells you this would be a great mark for you, and that bell goes off in the back of your head where you think, really? I think that just sounds descriptive. You're on the right track. Trust your own instincts there to say, I know why you're telling me that, but I really think that we have to go with something at the higher level, either suggestive, arbitrary, or fanciful. Now, there is a level even worse than descriptive. That's generic. Generic is the actual name of the product or service. So if you were coming up with a new dairy-based beverage, you really couldn't say, and my trademark is milk. Milk, obviously, just the generic term for that product. The reality is most new businesses are smart enough not to adopt a generic term at the beginning, but they're not careful how they use it over time. It eventually becomes generic. Escalator, aspirin, zipper, thermos, those were all marks registered in the US, but through misuse, they became generic. The Otis company had the registered trademark Escalator. It was the Escalator brand movable staircase. The true generic there was movable staircase. That's what everyone called those things that we take from one floor to the next, a movable staircase. Over time, Otis's own advertising people got sloppy. Instead of consistently saying the Escalator brand movable staircase, it started becoming the Escalator. Other people started saying, oh, the Escalator, without paying attention to who actually was making that particular movable staircase. When everyone was calling that thing the Escalator, it lost its trademark significance. That's why companies even today will try to remind you that their use is as a trademark. Xerox will say, that is a photocopy. It is not a Xerox. It is a Kleenex brand facial tissue. It's not a Kleenex. It's not a thing. As soon as it becomes a thing, then we're in trouble. Google will tell you that unless you're using the Google search engine, you are not Googling. Although many people think the ship has sailed on Google as far as that. So again, first big consideration, avoiding a likelihood of confusion. Second big consideration, making sure the trademark is a strong mark. Third consideration is paying attention to what the possibility of your business would be. What do I mean by that? If there is the possibility that the business will expand outside the United States, now is the time to figure out, might that trademark be problematic in a different country? Gerber Baby Food wanted to expand into France using the Gerber trademark until they learned that Gerber in French meant vomiting. Kind of a hard sell for a food product. Kentucky Fried Chicken, they wanted to use their slogan, finger licking good in China, except there it translated as eat your fingers off. Again, a problem. Now, this may not be an issue if you think, I'm only going to be here in the US, okay? But if your dream might be bigger than that, this is the time to worry about it. So again, looking at mark selection. Now, once you have your mark in mind and you think, I've gone through all the analysis, I think that it is registrable, I think it is legally protectable, the next thing is that we, the USPTO, we do hope that in fact you will seek federal registration. Again, not required, but it is the right business thing to do. If you're going to seek registration, how will you do this? Well, you're going to do it, again, through the USPTO website, using the Trademark Electronic Application System, or TEAS for short. Now, electronic filing, it is not mandatory, but today over 99% of our applications are received through TEAS. TEAS is more efficient, it is more cost effective, it increases the likelihood that your application will be approved for registration. So if you're considering applying, certainly consider applying through T's. Now, how does that process work? The application is submitted. Quite honestly, it is going to sit in our office for about 3 months. We get over 450,000 applications a year, so we have to take them in the order of receipt. So the first thing, it's going to just sit. Then it's going to be picked up by the examining attorney for review. The examining attorney is going to do the same search in the database to see if there's a mark already registered or pending that would block your application. If there's a minor problem in the application, the examining attorney is going to telephone or email. If there's a bigger problem, let's say the examining attorney does in fact find a mark already registered, so he or she will have to issue a letter known as an office action that is going to identify that there is a likelihood of confusion with this particular registration. There'll be an analysis there spelling out why the marks are confusingly similar, why the examining attorney believes that the goods are related. Now, at this point, you have the opportunity to respond back. You may look at that analysis and think, well, yes, the marks are similar, but actually the goods are not related. I don't think the examining attorney really understands what my product is. You can try to educate the examiner through a response. The examining attorney may in fact realize, well, now that you've gone into more detail, I realize these goods do not move in the same channels of trade. They really are not related. There was no basis for me to refuse this. I'm going to withdraw the refusal. Now, it's possible that doesn't happen, and in fact, the examining attorney is going to issue what's known as a final office action. At this point, you may realize, well, I'm kind of at a dead end here. Or you may think, you know, actually, I still believe in my own position. You can appeal to the Trademark Trial and Appeal Board. Now, the overall process, particularly when we have back and forth from the time of filing to the issuance of a registration, it's about a year. A lot of people think, oh, I'm simply buying a trademark. No, you are applying to seek registration. It has to go through the process. Registration is not guaranteed. And if you do not get a registration, there is no refund. Some people think at the end of the day, if I'm not successful, I can simply ask for my money back. No, that is a processing fee. So even if you don't get a registration, it's kind of unfortunate, but there's nothing more that we do about that. If you do get a registration, a lot of people think, I'm now finished. I have my registration, that's all I needed to do. The reality is, things are just beginning for you. Some people think that there's a body known as the trademark police. That's not the case. You, as the owner of the registration, are now responsible for enforcing your rights. And if you don't do that, it was probably silly of you to even get the registration. You have to remember a registration is really a sword. It's not a shield. It's a sword in the context if you are aware of someone that is in fact infringing your trademark, you have to be the one to send the cease and desist letter. You really don't want to receive one, but you do want to send one out if you are aware of an infringing situation. Why is that? If you're aware of another business that is infringing your mark and you sit back and do not do anything, it's very possible that you are going to lose business. someone is going to go to that other company, that other business, thinking that it is you. They end up having a very bad experience. They vow never to return. In fact, because they think that you're basically the same because of the confusingly similar marks, they never go back to you. Unwittingly, you have lost business. You were not even aware of the situation of someone going to that second business and having this bad experience. But because they correlated both of you, you have now lost business based on that other situation. So if you sit back and allow that to happen, you're only hurting yourself. Which is why, once you're aware of an infringing situation, you have to use that registration to try to put that other company out of business, or at a minimum, to make them change their mark. That's why it's very important to always patrol your own mark. Always be on the lookout to see, is there a possible infringing situation, and if so, to do something about it. So those are kind of the three main areas of concern: mark selection, seeking registration through applying at the USPTO, getting a registration, and then doing something with it. Now, once you have that registration, you have to be sure to take the steps to keep that alive. A registration for trademarks, unlike for patents or for copyrights, patents, copyrights, they are only good for a set period. The trademark registration can last forever as long as you take the steps to keep it alive. What are those steps? Between the 5th and 6th year after registration, you have to do another filing showing that you're still using the mark in commerce. Why is that? Well, unfortunately, most new businesses fail between the 2nd and 3rd year. If we didn't ask you to show us you're still using the mark at year 5, our register would be full of marks that simply are no longer in use. It's what we call deadwood. It's simply there, but no one is actually using that mark. We like to keep the register reflecting actual use. We clear out the deadwood. So if you fail to file that Section 8 document between the 5th and 6th year, we cancel the registration. Between the 9th and 10th year, you have to do a similar filing. Here again, you're still showing use of the mark. Now you're requesting renewal. And every 10 years thereafter, it's the same process. As long as you keep up with that, your mark will stay live on the register. And we have some marks that have now been on our register about 150 years. To make things easier for you in this regard, the end of January, we actually had a big policy change. What was that? Before, it was your responsibility to remember to file at year 5, year 9. We did not remind you about that. Now, because we do almost everything electronically, we decided as a customer service, we really should send out some sort of reminder. So that's what we've started doing. As long as you have a live registration and an active email address with our office, on the first day of the filing period at year 5, the first day at year 9, we're going to send you an email reminding you that the year period is now starting to run for you to make a submission. So we hope that that will be very helpful for registrants. So I started with a quote, I'm going to end with a quote, and then we're going to see if you have any questions. Benjamin Franklin. Did Benjamin Franklin have anything to do with trademarks? Not really. But what did he say? An ounce of prevention is worth a pound of cure. How does that fit into trademarks? The ounce of prevention is realizing at the outset, if there's a problem, if you are aware of someone already having a similar mark for related goods or services, that is the time to make the smart business decision and choose a different mark. The pound of cure is where you don't do that. You put your blinders on and say, I am aware of a problem, but I'm still going to move forward. What can happen? Well, ultimately, you can get into a dispute, and down the road, you are going to be forced to change your mark. You've now lost that goodwill that you were trying to build up because you went forward, you're using the mark, and now you have to change. Unfortunately, many business people, they become very bullheaded, very stubborn, particularly where they have come up with this mark on their own. They think this is the most creative, clever mark that anyone has ever seen. I love it so much, it's my baby. I don't care if someone else was equally as creative and came up with a very similar mark. I'm not giving my baby up. That is a bad business decision. The smart business decision is to say, as much as I love my baby, I'm going to have to adopt. I'm going to have to adopt a new baby because that, for business purposes, is really the smart thing to do. Any questions?
I have a very specific question that I may need to give a better example than I can verbally, but I'm working with Ashland's students and applying for a mark that is going to be the brand of the company. Yes, the company name, it'll be a word mark as well as a stylized mark. That's going to get used in different places in actually communicating things about what the company offers to consumers. Consumers and other kinds of customers as well. As that mark goes into different images, does that whole other image need to become trademarked as well when it has the actual mark as an element in it?
Right. Okay, so you're talking about a mark that perhaps is evolving. It has an element from the original, but it may morph into something else.
A good example is probably Coca-Cola.
Okay.
There's the word mark is number 2, the special form mark is number 3, and they're getting combined in the composite mark.
Right.
If you have those elements existing in the composite mark, how important is it to have the composite as well?
Right.
Because there could be a variety of those that are, communicating in different ways to the customer.
It all comes down to money, to be honest. Okay. If you're Coca-Cola, you have a lot of money, so you're going to seek registration for each of these variations. Okay, because each of these is a different filing, separate filing fee. So if you say, well, yes, I use it as the composite mark, sometimes I also do use separately just the wording, but I really only have the funds to do one filing, well, then you want to do the composite mark because that's protecting overall both the wording and the design element. Okay? But if you say, well, I actually have the money to do a second filing, and because I do use the words alone, well, then you want to go for the standard character format. The beauty of the standard character format, it says, I'm going to protect the words, but not the manner of display. So maybe you start out and you say, I want to give my company a very classic old world feel. So I'm going to use the Old English typeface this week. Next week, you think, that just makes my business look old and tired. I'm going to contemporize that and change the font to Arial. That looks much more modern. You can do that because the standard character format does not tie you to a particular manner of display. Versus the third one where Coca-Cola says, you know, that script is so recognizable, even if you couldn't really read those words and you saw the swooping, say, that's Coca-Cola. Now, back to the top one. That's shown in black and white because, again, that gives you the strongest protection. That's saying the actual components there, that's what we're protecting. Maybe this week we're doing it in yellow and green. Next week we realize, hate yellow and green. What were we thinking? Let's change it to red and blue. You can make that change because in black and white, you're not wed to a particular color combination. Now, on a related note, people will say, well, what happens when in my original application, I said pants. Next week, I realize, you know, I'm going to start doing shirts. So I'm going to add shirts to my application. You can't do that. You can narrow, but you cannot expand. So truly, if you wanted actual protection for shirts, you'd have to file a new application for shirts. Now, that's a bit of a stretch in terms of, obviously, we would not allow someone to register a similar mark for shirts if you already have it for pants. Okay? We'd use your existing registration to block theirs. But in terms of having absolute protection for shirts, well, you want a registration that says shirts, you can only get that by applying. You can't add.
In that composite mark, can anything change in that, or does it have to be exactly like it? Like, can there be an element in there that changes?
No. No. We are going to require a sample of how you're using it, known as a specimen, and we are going to look that that specimen usage matches exactly how you showed us in your application. You definitely cannot have a component. Some people say, well, I'm trying to register, we're a charitable service that every year we put on a fair to raise money. And so we have the name of our event, but the year it changes. You can't do that. You can't say, oh, here's an element that every year is going to change. We don't permit that.
Phantom marks don't exist? The XXXX?
We have definitely moved away. Phantom marks we used to have this policy that, yeah, you could use X's to show that this was an element, and in the description of the mark, you would identify, oh, well, the X is to show that this is an element that each year will change. We've definitely, as I said, we've kind of moved away from, I don't want to say that phantom marks don't exist at all anymore, but we're not as likely to accept that now as we were in the past.
So is it, if a year is included in XXX format, what is the probability that I'll lose my client's filing fee? That's the risk, right?
It's somewhat of a risk. Sometimes we'll say, you know, that element, because it was almost, I don't want to say not part of the mark, but we'll let you simply delete it entirely. A better example of that is if you have a mark, let's say it's soda, and it includes something like 12 ounces, we're going to say, you know, that's not really even part of the mark, it's just informational, and we'll have you delete it. But I'm not really sure why there's been that kind of policy shift with the phantom marks, to say we're not as comfortable as we once were with having phantom elements. Sure.
I have a question about legislation and common law. For example, there is a company A who use mark and register. After that, company A failed to maintain and the mark is dead. After that, company B a new business company found that the mark is dead and company B use that mark and register the mark, but the fact that company A still use that mark, what is the result of this case?
Okay, so I'm going to rephrase your question to make sure that this is what you're asking. This requires kind of a broader understanding of the USPTO practice. So company A, they were using the mark and they filed to seek registration. In fact, they do get registration, and you get to that Section 8 period for doing that filing, and they miss the deadline. Okay? We have no choice but to cancel that. Now, it is dead in our database, but it's possible they're still using the mark. For whatever reason, maybe they simply didn't docket this correctly. They missed that filing deadline. Again, we had no choice but to cancel it, but it is still in use. So you always have to be very careful if you see that a mark is dead. You have to find out, why is it dead? Is it dead because it's no longer being used, or is it dead because a deadline at the USPTO was missed? So for company B, they really won't know until they do more research in terms of, would this be wise for them to start using the mark? They need to find out, have those common law rights actually ceased? Again, common law predicated on use. If you are no longer using it, you have lost your common law rights. So have those rights truly ended, or has the registration simply been canceled? And if it's the latter, where the registration has been canceled but there's still use, then B really shouldn't start up with that mark, because A will still be able to assert their common law rights.
Can B get a registration on the trademark?
This is where it does get confusing. Okay, so he's asking, again, the scenario we were talking about, could B get a registration? The answer is yes. B will apply at the USPTO. We will look in our database to see, is there a live registration that should block that? We're going to find that registration, but we're going to see that it's dead. Well, we can't use a dead registration to block this one. So yes, we will issue a registration. You get your B, you get the registration, and then A is going to come back and try to cancel it based on their common law. Okay? So again, earlier when I said that common law can trump a registration, that's where it's confusing. It's like, well, why did we grant a registration? There was someone who had superior common law rights. We cannot look at the common law. We can only, USPTO, look at the database.
For the likelihood of confusion examples for exceed and exceed, those are pronounced pretty much the same anywhere in the US, but I'm wondering about cases where the actual dialect within the US might make a difference. Like, for example, if company A makes doghouse roofs, and they are Little Roof, R-O-O-F, and another company comes along and wants to make dog treats, and they're Little Rough, R-U-F-F. But there are parts of the country that pronounce the thing over a house as rough. So there are places where that's Little Rough and Little Rough, and there are places in the US where that's Little Roof and Little Rough.
Right. So there's a basic principle of trademark law. There is no such thing as a correct pronunciation of a mark. You, as the owner of the mark, you know how you would like it to be pronounced, but you cannot control how, in fact, it is pronounced. So if there's the possibility that some people are going to say both of these in a way that sounds confusingly similar, the problem exists, even though in your own mind you're saying, what? That's not how we say this. You're not going to win that, okay? If in fact someone can say, well, to me, they sound the same. Anything else? Okay, then I think we're good. And John, thank you very much for this opportunity.
Thank you, Greg.